Dunlop.
My Lords, my Lady, for the intervener, the Parole Board for Scotland, the position on the merits is similar to that of the Ministers and of the Advocate General, and I don't plan to detain the Court by repeating what they have said or what is in our written case. I adopt the submissions of my learned friends, Mr Moynihan and the Learned Advocate General, and I adopt our written case. And I confine myself to making 5 short observations. The first is that in this context, arbitrary imprisonment means the penal oblivion described by the Lord Chief Justice, Lord Judge, in the James case. It's paragraph 105, page MS 1127. One faces penal oblivion when there is no end in sight. That explains why practically every pronouncement that is seized upon by my learned friend Miss Bain is made in the context of indeterminate sentences. With such a sentence, there is no end in sight. Per contra, with determinate sentences. Now, my Lord Reid points out that one can find dicta in Strasbourg suggesting that rehabilitation is desirable in every situation of incarceration. Of course it is. No one could dispute that. But there is no case before this Court, no case that any counsel here has been able to find, domestically or in Strasbourg, where lack of availability of rehabilitation has led to a finding of a breach of any aspect of Article 5 of the Convention. The second observation is I draw attention to the illogicality of the appellant's position regarding when it is that the ancillary duty is said to arise in the context of this determinate sentence. It's not said to arise during the custodial part, and sensibly so, because at that point there is a guaranteed release date. It's not said to arise on release, because it would make little sense to have the ancillary duty applicable when the prisoner is no longer a prisoner but is at liberty. And accordingly, it can only arise on recall to prison at a point in time that cannot be predicted in advance, and at a point in time when that person may well be so close to sentence expiry that the duty is empty of content. And the Court will recall that practically the first thing that happens when a prisoner is recalled is that the case is put before the Parole Board. That is the 5-4 control for a recalled prisoner, any recalled prisoner, but certainly a recalled extended sentence prisoner. Now, if that's when the duty arises, well, at that point, the duty can be of no assistance, because when the person appears before the Parole Board, the duty won't have had a chance to do anything. So, in my submission, this Court should decline to impose a duty which is either otiose or impossible of fulfilment. The third observation is picking up on a comment made by my learned friend, the Advocate General. There is a clear conceptual difference between engagement of Article 5.4 in the first place and saying that the ancillary duty arises in the second. They do not necessarily march hand in hand. Certainly not so far as Strasbourg is concerned. as the last stage in Khayyam shows. And that gives rise to a rather clear oddity here that has been remarked upon in the course of discussions thus far. This court is asked to award damages under Section 8 of the Human Rights Act. Such damages can only be awarded if there has been an unlawful act. What is an unlawful act under Section 8? It tells us unlawful is to be defined under reference to Section 6. Section 6 says unlawful means a breach of convention rights. If Strasbourg wouldn't find a breach, as seems almost to be conceded in this discussion, then what is it that damages are being awarded for? And how is it that Section 8 can entitle any such award? The fourth observation is that I confess presently to be unclear on the basis of the appellant's argument as to why it is that extended sentences are being singled out. Now, true it is that Section 3A, subsection 4 of the 1993 Act draws attention to the notion of risk. But that does not mean that risk is absent. That does not mean that risk is not determinative in other cases. The simple fact of the matter is that for any prisoner whose case is put before the Parole Board for Scotland, the primary, usually the only consideration is that of risk. A recidivist heroin dealer who has never evinced violence cannot be made the subject of an extended sentence. But if, when on licence, after release at the 2/3 stage into a 14-year sentence, he reoffends and is recalled, the board is not going to be concerned with retribution. It's not going to be concerned with deterrence. Its primary concern, almost always, I could probably say always, although I'm reluctant to close it off, almost always, its only concern will be risk of reoffending. Now, this has been recognised judicially by the Lord Justice General, or the then Lord Justice General, Lord Hamilton, in the case of Petch. And if I can ask the Court just to turn that up briefly, it's Volume 1 in the Authorities Bundle, tab 10, and the MS number is 756.
Thank you. Yep.
756, the Lord Justice General quotes from the Parole Board for Scotland's corporate plan. And if the Court looks, it's about 2/3 of the way down the page, the second last indent.
Yes.
In its corporate plan 2005, the Board says, the Parole Board endeavours to ensure that those prisoners who are no longer regarded as presenting a risk to public safety during a period of parole may serve the remainder of their sentence in the community under the supervision of a social worker. It is not the responsibility of the Board to consider the questions of punishment and general deterrence. And then, having quoted further from a later report, the Lord Justice General says, these public statements on the part of the Board make it clear that it perceives its function to be, and only to be, to assess the risk, if any, which on the expiry of the punishment part, the life prisoner, if released, would present to the public. it does not, it seems, perceive its function as being concerned in any respect with the punitive element of the sentence. Now, that is said, of course, in the context of a life sentence, and therefore an indeterminate one, but as we see from the quote that I read, that is a general comment. And having consulted with the Chief Executive of the Parole Board for Scotland yesterday on this issue, he confirms that understanding. The Parole Board considers itself as dealing with risk and only with risk. It is not their remit to look at deterrence. It is not their remit to look at punishment.
But they can be asked by the ministers, though, to give recommendations.
Absolutely. Absolutely. Now, because the Parole Board is only concerning itself with risk.
Could I just ask you
I'm
this
sorry,
before we
ladies.
move on? It's on the related point. In England and Wales, the Secretary of State can give directions to the Parole Board as to the criteria the Parole Board uses and the things the Parole Board takes into account.
Yes.
And that makes it clear that it's basically the assessment of risk
Yes.
and the factors to be taken into account in the assessment of risk.
Yes.
Is there a similar system up here, or does the Parole Board set its own?
The Parole Board rules, my lady, Parole Board Rule 8 mentions, and I'll get your ladyship the MS number for that shortly. Parole Board 8 lists a non-exhaustive range of factors which the Parole Board can take into account. And if the court comes to look at it and ask, well, why are these things all relevant? It's because they all go to risk. Risk itself is, to be fair, expressly identified, but it's then things like the nature of the offence. It's what the offender has done since the offence, and its behaviour since the offence, all of which are relevant because they go to the question of risk. It's MS 1488 is Parole Board rules, Rule 8. I'm obliged to my learned friend. But the reason why I say this is of particular interest in the present context is that means that any case where continued incarceration or not depends on a decision of the Parole Board, the sole governing factor is risk. Now, if that is then going to be the criterion, that means that in every case that hits the Parole Board, the ancillary duty arises. Now, that is a massive expansion of the duty. It goes far beyond anything said by Strasbourg. It goes far beyond anything even urged by the appellant. But if that's the criterion, then that is the result. I suggest that approach is flawed because it involves ignoring the true distinction between an extended sentence and any other. In every case, the question is of risk. But in the generality of cases, the question for the board is this: can the risk of offending be managed in the community? For an extended sentence, that question is different. It's not the risk of recidivism, it's the risk of serious harm. There is thus a higher hurdle for the ministers who are opposing the release into the community of an extended sentence prisoner, because the question is there a risk not of reoffending simpliciter? Is there a risk of serious harm? And if there isn't, so if the risk is he's going to start shoplifting, that's not enough. It might be in other contexts, but for an extended sentence prisoner, it is not. Now, if I'm right in saying that is the true point in distinction, there is no reason why the other sentencing aims fall out of consideration. Now, mention was made yesterday of the English provisions which enshrine certain sentencing aims in statute. And my Lord Carloway points out that there is no Scottish statutory analogue. And of course he's right to say that. But as you will recall, there was a proposal so to enshrine, and the bill that was proposed is found in the authorities at tab 29, page MS 1424. Now that bill did not become law. Why? Well, again, I'm sure my Lord Carloway will recall, because I think he was Lord Justice Clerk at the time and involved in the process. The reason why it didn't become law was that the Justice Committee said these sentencing aims are already well enshrined in the common law, which is perfectly flexible. We need not codify it in this way. In my submission, there is nothing to say that those general sentencing aims are not part of an extended sentence, as with any other. Now, of course, the test for imposing an extended sentence is protection from serious harm. But that's not to say that the other aspects of sentencing are completely ignored or irrelevant. Retribution, deterrence, rehabilitation can all properly be said to be part of the imposition of an extended sentence. Even if they're not part of the test for imposing it, they are effects of such an imposition. And I remind the Court of what my Lord and the Chair said in Whiston. This is tab 26, paragraph 25, MS 1385. The general assumption for any determinate sentence is that all of the sentencing aims form part of the decision-making process. The final observation, before I look to the Board's particular concerns briefly. The final observation is this.
Can I just deny?
I'm sorry, my Lord.
Can I just deny any responsibility for the results of in relation to the sentencing bill? I had nothing to do with it.
I apologise if I inadvertently defamed my Lord.
It's a privileged occasion.
Indeed, indeed. The final observation is that the appellant's approach, whether confined to extended sentences, or whether, if we are just looking about risk as the determining factor, invoking the ancillary duty, goes far beyond any Strasbourg jurisprudence thus far. Now, there have been various judicial comments since Black about what Lord Brown said in Black, and both my Lord and the Chair and my Lady will recall the discussion of what was said. But the criticisms were surrounding what was said by Lord Brown in his run-up to his conclusions. There's no ultimate criticism of the conclusions. And what we find at paragraph 85 in Black, MS 821, is a comment that I suggest is particularly apposite here. That comment is that the court should decline to assimilate determinate and indeterminate sentences when Strasbourg has not yet done so. And as he points out there, that, under reference to ULA, is a question that should be left to Strasbourg.
I'm sorry, could you give me the page reference again?
It's MS 821, my lady.
821, thank
Black
you.
is tab 11, it's paragraph 85.
Thank you.
I'm obliged to Milena Junior, who points out that there is. My lady asked me about Secretary of State directions to the board. It's in section 20 of the 1993 Act, subsection 5. This is page MS 1471. There is provision for directions by the Secretary of State. As I understand it, none has yet been given, and rather the position is governed by the rules, in particular Rule 8, as I mentioned earlier.
Thank you.
So, my Lords, my Lady, for the reasons more widely stated in the statement of case and more narrowly on these 5 observations, the Board supports the submission made by both the Ministers and by the Advocate General. The duty here simply does not arise in this context. And the Board makes that submission where it has an ongoing practical interest in this question for various reasons. In the first instance, the Court will recall that the primary case made by the appellant was originally against the Board itself. Now, albeit the appellant has since the Outer House seen the error of his ways, the Board has a concern that others may not. Secondly, even allowing for the fact that no one suggests that this duty adheres to the Board, where the duty, the ancillary duty that we're talking about, arises, it is a factor in the Board's approach. In any given case where it is suggested that the duty arises and has been breached, the Board itself comes under pressure to exhort the prison service to remedy the perceived complaints, lest the Board is accused itself of condoning an ongoing breach. That then has the very practical effect of leading to adjournments, to delays, to shorter review periods, all to the detriment of good administration. Now, situations where the ancillary duty arises already form a material part of the Board's caseload. In the last 3 years, the Board had on average 351 cases per annum, which were indeterminate sentence cases, where the ancillary duty is unarguably in play. So that's either life imprisonment or order for lifelong restriction. In the same period, it had on average 354 recalled extended sentence prisoner cases per annum. So basically, if this Court accepts the appellant's argument in its narrow context, i.e. only extended sentences, in one fell swoop, the Court doubles the number of cases where the ancillary duty arises. And that's only if we are restricting ourselves to the appellant's argument. If one follows the logical consequence and says it's wherever risk is the guiding factor, well, I can't think of a case where the ancillary duty doesn't arise. Now, that in itself gives rise to significant resource implications, primarily for the respondents, I quite accept, but also on the Board, given the defensive approach, which is an instinctive reaction on the part of the Board when the duty is in play. Given that oftentimes the duty will, for the reasons I've already discussed, be something that is not actually going to have any practical effect because it will arise at a point shortly before expiry of sentence, where there's simply not enough time for rehabilitation to do anything, what your Lordships and my Lady would be doing would be imposing a significant guaranteed burden on the state and on the Board, where any concomitant benefit is wholly uncertain. And I don't want any more than my learned friend Mr. Moynihan to make submissions in terrorem, but there is a concern that this will just be a conveyor belt of claims. That is not an approach which should commend itself to this Court. and it's an approach which I urge the court not to follow. My Lords and my Lady, those are the observations I wish to make. Those are the reasons why the board has asked for and been granted leave to make these brief submissions as intervener. I'm happy to answer any questions that any member of the court may have, but other than that, those are the submissions for the board.
Can I ask you a couple of questions, Mr. Lord? One trivial, one more significant. The trivial one, you're actually the respondent to the petition, aren't you?
Well, that was an interesting question. So we weren't sure whether or not we needed leave to intervene.
No.
Because no challenge was made against us in the Inner House, because we played no part in the Inner House, we considered that there was at least a risk that we were no longer party. Hence, we applied for leave to intervene. Your Lordship
Yes.
may be quite correct.
Well, I was just wondering about that. And whereas the Advocate General is an intervener, I think.
Indeed, but is described as a respondent.
Yes, right. Clear that. The other point is the Inner House, in the second last paragraph of the judgment delivered by Lady Clark.
Does your Lordship have an MS number?
Yes, it's MS 222 to 223.
Right.
And she refers to the history that's been set out more fully in paragraphs 6 to 13. And then at the foot of the page of 222, she says, we do accept there was delay in providing courses recommended by the first respondent, which was the Parole Board. Looking at the matter broadly, we consider that a period of 18 months may be taken as a relevant period of delay in this case. Are we to treat that as a finding of fact?
For obvious reasons, my Lord, I have joined no issue on the question of quantum.
Yeah.
I think the difficulty in treating that as a finding in fact would be that the process that's gone through here with a judicial review, there was no second hearing, there was no particular exploration of a factual narrative other than that which was agreed between the parties. I think all that the court can do is address itself to what's in the agreed chronology now before the court, and also to look at the agreed documents, for example, in the dossier relating to the prisoner's behaviour while incarcerated. I think the submissions made by both, certainly by the Advocate General, suggest that the choice is actually between 2 years or 6 months. I'm not sure how one gets to 18.
Well, exactly. There's no explanation of how it's arrived at. And clearly, if one accepted the Advocate General's arguments, one would be looking at a much shorter, because the starting point of the period would be much later in time than would allow an 18-month period to exist.
Yes, indeed. And insofar as I have any locus in that regard, in my submission, that the logical approach is that advanced by the Advocate General, because when one's still in the custodial part, it's very difficult to see why, as I've already submitted, why that duty arises. And so it is the later period. But the passage that my Lord identifies does reinforce the point I make about what the board does when it's... the board was already, so before the ancillary duty was said to arise, the board would exhort certain courses, and it still does so. The concern is that where the ancillary duty arises is said to be breached, they now feel the need to go yet further than that. And the practical effect is where ordinarily there would be a review after a year, let's say. In terms of Oldham, there can't be more than 2 years. The board's practice is 1 year. If they're concerned that there's an ongoing complaint of breach of the ancillary duty, then what they tend to do is say, we'll have a review after 6 months. Now, if you then start doubling the reviews in every case, that has resource implications. The board is sitting more regularly.
Thank you very much.
Obliged.
Thank you very much indeed, Mr. Johnson. Ms. Fordyce? Thank you very much. Ms. Bain? If you want to make the usual arrangements, Mr. Dunlop, I think your lectern may be required to be passed along.
my lords, my lady, it is true that the appellant did get into trouble in prison, and it's correct to say, as my Lord Reid said, that the Parole Board in December 2012, 2 years after the first Parole Board at which the appellant appeared, identified that the coursework that had been identified as necessary for the appellant hadn't in fact been undertaken. And the relevant entry in the core volume in relation to the Parole Board statements in December 2012 is at MS 277. And I think that Lord Reid in particular was looking at the third paragraph from the bottom, yes, and asking questions in that regard. And the paragraph reads that the tribunal determined that you should remain in custody and progress in terms of the management plan. It accepted that similar plans were presented in 2010 and 2011, and little progress has been made, partly as you've been able to access programme work. The tribunal expects that in the next 12 months you will be given the opportunities detailed by the ERLO, the Early Release Officer, to complete the identified programmes. However, the tribunal also noted that you have incurred 5 misconduct reports in 2012, which would have been taken into account in consideration of a decision about your suitability to progress. The responsibility for these governor's reports lies with you. Indeed, you accepted that it's only you who can use the strategies to manage your impulsivity and improve your decision-making. The tribunal would encourage you to engage with the management plan. So it would seem to be reading from that there was little progress, partly because he had been able to access programme work. What it doesn't say is that the misconduct reports that he incurred restricted his access to the programme work in any way. And indeed it was an aspect of a discussion before the Outer House in relation to judicial review as to whether or not this properly reflected the situation that existed in relation to the appellant's position within the prison that he was in at that time. And I say that because I think it is important to show this court that there were other aspects to the progress of the appellant, and this can be seen at MS 96 to MS 97 of the core bundle.
MS 96 to 97?
Yes.
Thank you.
And this is part of the appellant's written case, but directly quotes from material that's from the Parole Board dossier, and which is available. In August 2012, MS page 96, Mr. Murray, the social worker who was involved with the appellant, wrote to the Parole Board and said that Mr. Brown had not completed the offence-focused work required, but this is through no fault of his own. He has now been assessed as suitable for constructs, and Mr. Zagdani has confirmed that it's more likely that Mr. Brown will attend the course in November. We know that didn't happen. He goes on to say then that Ian Murray also wrote a report in November of 2012 saying that the ICM had held a meeting on the 19th of November, and Mr. Brown advised that he'd been informed approximately 1 week prior to the commencement of his constructs course that it had been cancelled. The writer has subsequently been advised that constructs and care courses are very unlikely to be run again until June or July of 2013. Clearly, because of the interruption to programmes, he will not now be considered for progression. And so the author of this letter links the failure in relation to progression to the interruption of the programmes, and goes on to say Mr. Brown would need to complete the identified courses prior to any move to open conditions. It would appear that, therefore, that at this juncture, Mr. Brown is not able to undertake constructs at Addiwell through no fault of his own. And then in the submission that was made to the Parole Board in 2012, in the over-review for that, it was recorded as in the following way. At Mr. Brown's last hearing, it was noted that he would need to redo constructs and BPP. Mr. Brown was assessed by the intervention team and deemed suitable to undertake constructs and care. There is no reference to VPP. Both social work and Mr. Brown were advised that he would be commencing constructs in November 2012. Due to changes in the intervention team, this programme has not taken place. At Mr. Brown's ICM in November, it was noted he hadn't completed the programme work and that this was no fault of his own. And in June of 2012, his own personal officer wrote, "I have known the prisoner since December 2011. Billy is very keen to keep the parole process going and is vocal in his efforts to ensure that he completes the correct programmes in time for his parole qualifying date. Billy has recently been told he has to complete constructs and care. He is very willing to do these, but is frustrated at the length of time he is waiting to complete them." And this frustration was indeed reflected in letters that Mr. Brown wrote expressing frustration and anxiety over the process, and these letters are at MS 405 and MS 406. Just to show these quickly. At MS 405, the prisoner has written, on Friday the 3rd of August, Cadawer from the ICM team was on 4th C Hall, so I approached him and asked him what was happening about me getting in one of these two courses, up-and-coming construct courses. He then said, "I'm not on the list for any of these two courses, not even as a reserve." He then said he would come back and see me about getting placed on one of them. But he said he'd come back on Monday the 6th of August and see me. It's now Friday the 10th, and he's still not come to see me. This is now the 4th time he said he would come back and see me to sort out getting on courses, and now the 4th time he's not been true to his word. I feel this establishment is not doing enough to help me do my necessary courses, as I've been here 14 months and been trying to get on constructs 14 months, and this establishment said once I first arrived they would get me on the courses ASAP and help any way they could, but I feel they have also not been true to their word, so it would be appreciated if you could look into someone helping me with my case. And then similarly in the same vein, there's another document on page 406, and there are also other letters that we can see at MS 396, for example. Just in the middle of that page.
Could you give the reference again, please?
MS 396.
396.
And just in the middle of that page, I've also tried everything within my power to be placed on the constructs programme, and through no fault of my own or lack of willingness to complete this programme, I've not been placed on the construct course. I had to go through the complaints procedure to get some answers of when I would be placed on this programme, as I've been trying to complete this programme for over 2 years, and I felt I was receiving no help to be placed on this course, or told I would be placed on this programme until I handed in forms and went through the complaints procedure. There was an earlier letter in the same vein too. So it is reasonable to look at whether or not, because of the appellant's conduct, he was not given access to courses. That is not, in my respectful submission, borne out by the material that was put before the Parole Board, or indeed reflected in the letters that they had received. and that was very much an issue at the judicial review hearing. But what I would say in this context is that it is a rather weak argument, however, to hold against the prisoner because of misconduct, where it has been identified that he requires rehabilitation. Now, presumably, we operate on the basis that prisoners need to undertake coursework to reform themselves. This is, of course, the recognition that the prisoner, there is, of course, a recognition that the prisoner himself has personal responsibility. However, I would submit there is a question of the degree to which that squares with the need to do coursework to rehabilitate oneself. Why should it count against a prisoner who is assessed as requiring, for example, violence protection work, that they have been violent? That suggests the person really ought to be given intervention rather than it counting against him in some way. So I think it's an issue that needs mature and careful reflection in the sense that it might impact on the value of a claim, but it's also something that really needs to be considered with care in a context of a case such as this, namely a recalled extended sentence prisoner in respect of whom previous rehabilitation plainly hasn't worked. And I say to hold against him because he's violent and needing rehabilitation just doesn't make sense in the context of what we're dealing with. And in relation to the Addywell transfer that the Learned Advocate General mentioned yesterday, he was not transferred simply because of a fight. He was going to be transferred anyway. And what happened was that there was a transfer earlier than might have been otherwise because of something that he was involved in, some violent episode that he was involved in his earlier prison establishment. And that can be seen if we look at MS 351 and the bottom line of that page.
Thank you.
MS 351.
Yep.
So it said, Mr. Short advised that Mr. Brown was involved in a fight with another prisoner in the stairwell. This resulted in an early transfer to HMP Addywell. But it is the case that he was going to be going there in any event. Next issue that I would like to look at is the question of when the duty arises and the rationale given by Mr. Moynihan, the Learned Advocate General, supported by Mr. Dunlop for the intervener, that it makes no sense for a duty to arise in this case, because at the stage at which it's suggested that it could arise. I think it's important, in my respectful submission, to remember that this is a recalled extended sentence prisoner, and that he is in the position that was identified in James against the UK at paragraph 194, MS 1730. MS 1730. It's in volume 2, I'm sorry. Yes, it's volume 5, and it's page 1730, and what I'd like to remind my lord and my lady is what was said in that paragraph. And it begins by, at the point that I would begin to look at starts with, a concern may arise.
Which paragraph are you in?
Paragraph 194.
Thank you.
It says, a concern may arise in the case of persons who, having served the punishment element of their sentences, are in detention solely because of the risk they pose to the public, if there are no special measures, instruments or institutions in place other than those available to ordinary long-term prisoners, aimed at reducing the danger they present and at limiting the duration of their detention to what is strictly necessary in order to prevent them from committing further offences. Recalled extended sentence prisoners, and indeed extended sentence prisoners, are not ordinary long-term prisoners. They are serving a sentence that includes a significant element for public protection. It is determinate in the sense that it has an end date, but it is for public protection. And this end date has not precluded the European jurisprudence from identifying the need for review for such a prisoner. Indeed, that is very much the position that was adopted by the European Court in the case of Van Drugenbroek, which has been such an influential case in our jurisprudence in looking at the stage at which Article 5.4 applies, because it very much focuses on the need for a review where you're in a position where the decision as to an individual's detention, continued detention, is within the hands of the parole board, and where circumstances may change over time that require a review. So contrary to what Mr. Dunlop says, there's strong European jurisprudence to support the position of the appellant in this case, and indeed it is as discussed extensively by Lord Hope in the case of Giles, and it is our recognised jurisprudence. But the key element of the jurisprudence, both from James and the other jurisprudence we looked at, is not indeterminate sentences, but the public protection element and the question of risk. Mr. Moynihan and the Advocate General and interveners say that one of the reasons why the implied ancillary duty should not apply in this case is because of the point at which it's suggested it should be applied, the point of recall. They say it's not logical to start then, because sometimes the extended sentence period is not long enough for a rehabilitation programme to operate. And they also say it makes no sense, because really, if it's going to have any impact, it should begin before then, and to imply the ancillary duty only at that stage would have very little utility in practice. Mr. Moynihan relied on figures in relation to what extended sentence prisoners may be serving by way of the extended period in order to support his proposition in this regard. However, on the other side of the coin, I can say in my experience and from information I have been given by those practising in the field, there are examples of prisoners who are well within the period of their extended sentence, and they are still in prison many years beyond the date of the expiry of their custodial period and beyond a period of 5 years. So there are many examples, presumably, that can be shown to support Mr. Moynihan's argument and to show the concerns that legitimately arise when someone is in preventive custody for a period of many years, where there is no opportunity to rehabilitate and to demonstrate to the parole board that they've reduced their risk. They also relied on the fact that in any event, the case of Cayenne recognises an ancillary duty and that really should begin to be put into place by the prison authorities before the tariff expiry. And for all these reasons, they say the duty should not apply. In my respectful submission, that is not an attractive argument at all. And the alternative should be, if it doesn't just arise at recall, then the duty applies at an earlier stage, rather than it not applying at all. And it may be possible to identify for extended sentence prisoners a period before their release in which the duty may arise. But for my purposes, in this case, I say it does arise, and it arises at the latest at the point at which Mr. Brown was recalled to custody. The notion that you just don't apply the duty because it's being asked to be applied too late has no attractiveness at all. One should apply the duty rather than not at all, given the real benefit of the implied ancillary duty, which is to facilitate release and to facilitate the rehabilitation of violent offenders. My final point is in relation to the question of the public interest insofar as Mr. Moynihan's submission went. He suggested that the public interest is best served by the present arrangements and raises the prospect of a conveyor belt of claims as a reason not to hold that the ancillary duty applies to Mr. Brown. In assessing what the public interest is, there is obviously always a balance to be struck in any analysis before one properly identifies where the public interest arises. What we do know in the context of such an analysis is that an extended sentence prisoner is a violent or sexual offender who merits the imposition of a sentence that's based on their increased risk. In terms of the public interest and public protection, such a prisoner is a prime candidate for reform. An extended sentence prisoner who is recalled, by virtue of his recall, is found not to have benefited to a sufficient extent from any of the experiences or opportunities to which they've been exposed prior to their release. Thus, it could be said he is a prime candidate for further reform. And so, in terms of the public interest, therefore, I would suggest it's far better to conclude that the application of the ancillary duty should be applied. The public interest is best served by the duty to facilitate rehabilitation and release applying to such a prisoner. Rather than by way of aspiration, rehabilitation should be placed as a duty on the state, and consequently the individual prisoner should have a right to enforce such a duty, not only in his interests, but in the public interest too. So I suggest that the scaremongering that is being advanced by the government through Mr. Moynihan's representations and by the Learned Advocate General, and indeed supported by the Parole Board, is just that. And what we need to do in the sense of rehabilitation and protection of the public interest and securing a society that's a mature society and one that properly understands a whole variety of needs, interests and risks, that the implied ancillary duty should be seen as a very important development, a very serious and important development in our jurisprudence, recognising the real need for rehabilitation in order to protect the public interest. And it shouldn't just be aspirational. It should be the way that the Supreme Court previously identified in Khayyam, in the sense that this Supreme Court identified the need to recognise what this fourth section's ambition was, aspiration was, and to frame it within a duty that's accessible and means something rather than just aspirational, as Mr. Moynihan and the Learned Advocate General suggests. We should go about rehabilitation in this country. So I say the public interest is best served by the application of an implied ancillary duty to a prisoner such as Mr. Brown, who's recalled and to prison, and he was recalled on the basis of a very minor offence, one in respect of which he served 40 days in prison and then proceeded to serve a further 5 years. The only other point I wish to raise is what Mr. Dunlop said about the case of Black. And he referred to paragraph 85 of that, yes, as saying look at this and look at what the court really meant in the context of this case. But I would like to look at what was said before that at MS 817.
Thank you. Yep.
So Mr. Dunlop very much relied on paragraph 85 and showing what was said by that court in relation to the distinction between determinate and indeterminate sentences. But that really wasn't the focus of the court's decision-making in Brown, in Black rather, and it was very much one that also looked at the distinction between prisoners who had reached the point of mandatory release and prisoners who hadn't. And I think that a very helpful paragraph, in addition to paragraph 73, that was looked at by Lady Hale in the case of Whiston, to look on and see what was said by Lord Brown at paragraph 74. Because it shows again what I say about the European jurisprudence and our jurisprudence in fact supporting our position rather than not. At 74 it says this: inescapably it follows from West that contrary to the view expressed in the Strasbourg Court's admissibility decision in Brown, a prisoner's recall for breach of his licence conditions does raise new issues affecting the lawfulness of his detention, such as to engage Article 5.4. And that seems to me clearly correct. It would not be lawful to recall a prisoner unless he had breached his licence conditions, and there could well be an issue as to this. I wonder indeed if the European Court would have decided Brown as he did had it followed, rather than preceded, the House's decision in West. Be that as it may, recall cases, certainly so far as domestic law goes, are to be treated as akin both to lifer cases in the post-tariff period and to the Van Drukenbroek type of case, where upon the expiry of a sentence, a prisoner is subjected to an executive power or preventive detention. So he very much brings into line the situation of a prisoner who was in detention, and this decision as to whether or not his release lay not within the hands of the court, but within the hands of the executive. They describe it there, but in our purposes, it's the Parole Board for Scotland. And there are situations that affect the lawfulness of the detention. New issues arise. And so, rather than Lord Brown not supporting what the appellant advances in this case, there is support, and it's very powerful support, as can be traced throughout the decisions prior to the Whiston decision that I suggest Lord Neuberger wrongly decided in relation to his obituary remarks, and Lady Hale was correct. And the final point that I would make is what was finally said about this increasing the need for resources on the Parole Board for Scotland. I don't understand why there should be such an increase in the need for resources. The Parole Board for Scotland has the duty to assess risk, and there's a particular test that they apply for extended sentence prisoners. They apply the test and they go about their duties. Now, why, if they're doing their work in applying the test that's established by statute, which they have done since the statutory provision was put in place, why, if there's no change in that test, should it change anything? I don't understand what the analysis is that Mr. Dunlop provides for that, and I would suggest that we'd need something far more than just saying it's going to trouble people, that this is a new or extended duty. I don't understand it to be suggested, for example, that since the development of the implied ancillary duty in the case of Kayam, that the Parole Board can properly point to an increase in the number of hearings that they've had for life sentence prisoners or prisoners serving orders for lifelong restriction. So I would ask the court to exercise some caution before they simply accept that it's going to increase the need for resources on the Parole Board. If that is so, it might be for a short period until such time as the bedding in of the principles identified in Kayam and that should properly be applied to a sentence such as this come into effect. So it might be a short-lived problem, but it's a problem that needs to be identified if it is one, which I question given the fact that the same test is to be applied by the Parole Board. And those are the only points that I would wish to make in response.
Thank you very much indeed. Thank you.
Well, Lydia, with apologies for getting to my feet, can I make one observation standing on our friend the lines?
Yes.
And I remind the court that that is the paragraph that was expressly disapproved in Whiston, and the court sees that MS 1377 at the top of the page, dictum of Lord Brown of Eton-under-Haywood, paragraph 74, disapproved.
Could you give the reference again, please? I'm sorry.
1377, it's in the head note in Whiston, my lord. At the
I
top
think
of that
that was
page.
inherent in Miss Bain's submission when she made the point that we should prefer what Lady Hale said in Wisdom. Very well. Miss Bain, Mr. Moynihan, Advocate General, and Mr. Dunlop, thank you very much for your oral submissions. Thank you very much also to all those involved in preparing the written cases that we found very helpful. We will consider this matter and let you know our decision in due course. This hearing marks the end of the Supreme Court's historic first sitting in Edinburgh. We're very grateful to all those who've enabled this to take place and who've looked after us so well, including the Lord President and his staff, the courts and the Tribunal Service, the Lord Provost and the staff at City Chambers, and members of the judiciary, the legal profession, the university and the police. Thank you also to all of you who've taken the trouble to come and see the hearings, which was one of the main purposes of our sitting in Edinburgh. There have been many members of the public here throughout the hearings, and we were full to capacity for much of yesterday. I think that establishes that there's been a real public interest. We look forward to returning, but before then we hope to sit in other capitals of the United Kingdom. We're exploring the possibilities of Belfast next year. Thank you all once again. The court is now adjourned.